Hello everyone, and a belated Happy New Year to you all. I'm Professor David Cantor, and as Director of the Refugee Law Initiative, it's my very great pleasure to welcome you to the 12th Annual Refugee Law Initiative Seminar Series, run in partnership this year with the University of London Refugee Law Clinic. This series of 6 webinars delves into the topic of asylum after COVID-19, looking at the UK's new plan for immigration in a global context. Our objective is to interrogate how, as the global COVID-19 pandemic grinds on, states and other actors are re-engaging with the issue of asylum. Each session in this series thus evaluates distinct aspects of the UK's so-called new plan for immigration in detail, and by putting it in the context of broader global trends. In the first 3 sessions of the series, we considered the local and global implications of proposals in the new plan to introduce a discriminatory 2-tier system of refugee status, to mandate an unworkable interpretation of the refugee definition, and to limit access to justice for those seeking asylum. In this 4th session, today titled Asylum and Illegality, Protecting Refugees or Criminalising Asylum-Seeking, we look at how the new plan for immigration and its 2021 Nationality and Borders Bill seeks to render a wide range of activities connected with asylum-seeking in the UK as liable to criminal prosecution. Even so, in global context, it's clear that this increasing penalisation of asylum-seeking by the UK is not new. Indeed, criminalising irregular cross-border movement is a key strand of the securitisation agenda pursued by many governments across the world. However, in the UK, this narrative has reached fever pitch recently, apparently as a result of a steep increase in asylum seekers arriving by boat across the English Channel during the pandemic, when few other modes of entry would have been possible. Purportedly as a means to combat people smuggling and to avoid the risks which such methods of travel pose for asylum seekers, the 2021 Nationality and Borders Bill thus advances a raft of measures concerned with penalising the irregular arrival of asylum seekers in the UK, as well as reinforcing the conceptual link between asylum seeking and issues of illegality, trafficking and slavery. This seminar interrogates the rationale, scope and implications of such criminalisation clauses in the UK legislation and beyond. Specifically, we inquire, how have regular and irregular cross-border movements to the UK and elsewhere been shaped by the pandemic and the border lockdowns and other measures imposed by governments as a response? Why does such a high degree of political hysteria appear to exist in the UK, Australia and other countries about so-called boat arrivals, and is it justified? What's the legal and practical impact of the kinds of criminalisation measures that we see in the new plan and similar instruments that link asylum with illegality and criminality? To help us understand these aspects of the current situation and their implications for the UK and for the global refugee regime, we're truly fortunate to be joined today by 3 expert discussants. Although we'd originally arranged for 4, Lucy Mayer is unfortunately ill and will be unable to join us today. Nonetheless, I'll introduce the other 3 discussants who I'm very pleased to welcome just in turn before they speak. The format of the seminar starts with a presentation from a Refugee Law Clinic volunteer lawyer, describing the main pertinent features of the new proposed measures in the UK's 2021 Nationality and Borders Bill and the new plan for immigration. Each of the 3 panellists will then briefly present their initial thoughts on a particular aspect of those proposals. After that, we'll open to a wider discussion format where the panellists can engage with one another and with questions and comments from the other participants in the session. During the initial presentations by panellists then, please do have a think about questions that you'd like to introduce to the discussion and start typing them into the chat box that you can see on this side of your screen. Finally, I'd like to ask that you please do keep your microphones on mute and your videos off unless you're a presenter. We will also be recording this session the podcast of which should be available in the coming weeks on the RLI website. So without further ado, let me turn to our first speaker. I'm really pleased to introduce George Tyler, a solicitor advocate at Clifford Chance, one of the two law firm partners in the Refugee Law Clinic, where George volunteers. George is going to be introducing some of the main clauses of the 2021 bill concerned with criminalisation in the context of asylum seeking. Over to you, George.
Thank you, David. So as David said, I'm going to summarise the sort of relevant criminalisation provisions in the Nationality and Borders Bill before handing over to our expert speakers. So the government's criminalisation proposals really can be grouped into two different themes. Firstly, those proposals that make it illegal to enter the UK irregularly or to assist someone to enter the UK irregularly. And second, those proposals that criminalise individuals and businesses who unknowingly facilitate irregular entry. So just in relation to that first category, Clause 39 of the bill proposes to introduce offences for anyone who enters the UK irregularly, for example, in breach of a deportation order or without a valid travel document or without entry clearance, or anyone who falls into irregularity while in the UK. So for example, by remaining in the UK beyond the time permitted by their leave. The UNHCR is highly critical of this provision. It states that given that there is no possibility under UK law of applying for entry clearance in order to claim asylum, no one from a country whose citizens normally need a visa would be able to come to the UK to seek asylum without potentially committing a criminal offence as a result of this provision. In any case, the bill now also proposes that individuals who commit any of those irregular entry offences may be liable for either imprisonment for up to 12 months or, if convicted on indictment, imprisonment for up to 4 or 5 years. Clause 40 of the bill proposes to increase the severity of existing offences and to introduce new offences for individuals who knowingly facilitate irregular entry. So currently, the Immigration Act only penalises individuals who assist asylum seekers to enter the country irregularly if they do so for gain. The bill proposes to omit that qualification for gain, meaning anyone assisting asylum seekers to enter the UK may commit an offence no matter what the reason they assist them for, so either for gain or not for gain. Again, the UNHCR is highly critical of this provision and has stated that the most obvious target for this offence is refugees who assist each other to come to the United Kingdom to claim asylum, or friends, family members, and others with purely humanitarian motives would also be criminalised. The UNHCR says that even trafficking victims could face criminal penalties under this new provision. So the bill also proposes to make it an offence to rescue individuals at sea and to deliver them to the UK, or even to steer a ship to the UK, if doing so would facilitate irregular entry, with some important qualifications in the bill. So in addition to proposing these sort of more severe or new facilitation of irregular entry offences, the bill now proposes to increase the penalty for assisting unlawful immigration from previously imprisonment for up to 14 years to now life imprisonment. So we see an expansion both in the range of proposed offences under the new bill and also in the severity of penalties for those offences. So the second category of offences, very briefly, is sort of the criminalisation of unknowingly facilitating regular entry. So Clause 41 and Schedule 5 of the bill introduce penalties on individuals and businesses who fail to adequately secure, for example, a goods vehicle against unauthorised access by asylum seekers. And similarly, Clause 72 of the bill introduces fines for the owners of ships and aircraft who fail to carry out appropriate checks on the documentation of individuals entering the UK. So I hope that gives a sort of very quick introduction to the bill and gives a sense of the sort of breadth and severity of the criminalisation proposals that are set out. And I'll now hand back to David.
Many thanks indeed, George. For those who've just joined, that was a brief summary of the main provisions relating to criminalisation in the new legislation tabled by the UK government. Thank you very much, George, for leading us through those so ably. I'm going to turn now to the first of our discussants, and it's a real pleasure to introduce Dr. Anna Aliverti, who's from the School of Law, University of Warwick. And Anna will be talking through some of the implications for refugee protection in the UK of these proposals in the new plan, in the bill, around increased penalisation for irregular entry. This is very much in her area of work, and I'll be putting her bio up in the chat in just a moment. So Anna, really delighted to have you here. Over to you.
Thank you very much, David, and thank you for the invitation. I'm really pleased about being here. I'm going to go to the point based on the guidelines for this session, and perhaps we can elaborate on some of the points in the Q&A. So it's just to follow up on the very helpful introduction by George, new plan for immigration in Chapter 7 quite explicitly deals with the question of criminalisation and penalisation of immigration. And as he mentioned, there's two important categories here. The changes proposed to the 1971 Act in relation to entering illegally, in which there is changes in the penalties provided, and the offences of facilitation, particularly for our purposes, the facilitation of asylum seekers to claim asylum in the UK. There's, of course, an important and controversial provision around border force powers to stop and redirect vessels out of UK territorial seas. And there's also that provision that also George referred to around civil penalties that would reconfigure the civil penalty regime in a slightly inchoate mode, that is that carriers are liable for not properly secure their transportation, even though there is nobody found to be in breach in those carriers. My views on the implication on the criminalisation of asylum seekers is twofold. So in relation to the criminalisation of illegal entrance, we see, as George mentioned, that this is primarily a change of in the penalty, and increase in the penalties level to those found liable, prosecuted and liable. Although I would say having work on this area and also research the practice of the use of criminal law in this context, the use of criminal law, the use of prosecutions against asylum seekers and in general illegal migrants in this context has been going down since the 2010, and although prosecution statistics are not longer publicly available, we've seen a downward trend. It is also important to understand that the use of criminal law in this context has been generally used instrumentally, therefore where administrative routes were not available, where removal was not available, and where the Home Office sought to have individuals in prison, for example, and they couldn't help the migrants in any other way, so they use criminal sanctions for that purpose. But that use, very instrumental use of criminal law, has been severely criticized by the Criminal Case Review Commission for in a number of cases where wrongful convictions were declared of refugees who had been wrongfully convicted, particularly through this Section 2 of the Asylum and Immigration Act 2004 and Section 25 of the Identity Cards Act 2010. So after those wrongful convictions were declared, there were a significant revision by the prosecution service, the crime prosecution service, to use criminal law in these cases. So in that regard, then I don't see that these increases in penalties will change the picture in this in relation to the criminalization of people seeking asylum. I think where the implications of the plan will be much more important is on the criminalization of humanitarian organizations and individuals for and also transport companies for helping asylum seekers, particularly the reform, the plan reform of Section 25A of the 1971A is particularly alarming in terms of the removal of the four-gain criteria and the no differentiation between commercial facilitators and humanitarian facilitators, and the huge restrictions that have been introduced in the nationality and border bills, particularly in relation to when it is applicable, the exemptions to penalties and the work of the defense, where so it only applies where the person assisted is in danger or distress at sea, and the act of facilitation involves delivering the person to safety, but does not include where the UK is not the nearest place of safety, and there are not good reasons for delivering the assisted person there. And also another important exception that is linked to last year's Court of Appeal decision on the case of Fawad Kakay is that the assisted person should not be on the same ship as the facilitator, and the facilitator is steering the ship. Is very, the factual situation is very similar to the case of Kakay, and I suspect it has been introduced to cater for those situations. So just to summarize, I think that these changes to the facilitation offenses are going to be quite detrimental to refugee protections. And it's really a reminder of the debates that have been happening at the EU level 5 years ago during the refugee crisis, where the facilitation directive was reassessed. And it's not a coincidence, given that this piece of legislation, the Nationality and Border Bill, is mainly aimed at tackling a particular issue, the issue of the arrival of small boats in the English Channel, and thinking about concerns about people in policy circles and practitioners working at Dover, that the English Channel is risk becoming a new Mediterranean. I think this is quite crucial in terms of understanding the context in which this piece of legislation is being debated and will come into force. Thank you.
Brilliant. Well, many thanks indeed, Anna. I mean, certainly that's a good point on which to end. You know, is the English Channel in becoming a new Mediterranean, as it were? That's the context for the debates that you see around some of these facilitation offences. And also the interesting point that you raised about the extent to which actually the prosecution of asylum seekers themselves are likely to take place. I mean, there's a question about, well, you know, firstly, how objectionable are these provisions when on the statute book, but also how are they used, when are they used? And drawing on your research there, I think is really very illuminating as to where that may possibly go. So thank you very much. For those who joined late, our second speaker, Lucy Mayer, is unable to join us, unfortunately, due to illness. And therefore, it gives me very great pleasure instead to go directly to our next speaker, Dr. Kudakwashe Vanyoro from the African Centre for Migration and Society at the University of Witwatersrand in South Africa. And we're really looking forward to your intervention, Dr. Vanyoro, seeing outside the UK, South Africa as possibly a comparative example in this wider trend of governments criminalising activities related to or in some way connected to asylum seeking. So over to you.
Yeah. Thank you very much for that introduction. And thanks to the first speaker for such a compelling start. And of course, George, for laying out the bill for us, for those of us who are not familiar with it. I really think this is an interesting conversation in light of how sort of Europe, as it were, you know, used to sort of be the shining light in terms of some of these issues. But, you know, hearing how where things are going is also a little bit concerning about how it's pretty much falling within the same kind of approach that they, you know, that, for example, in spaces such as the Global Forum for Migration and Development, that were opened up, as well as to talk about some of these issues. They you know, it's really difficult to see who would take the lead now, because the case in South Africa is similarly concerning, is in some parts as well of the continent. So South Africa basically is currently regulates migration through two pieces of legislation, which is one, there's the Refugee Act, which regulates asylum seekers and the rights of refugees to enter and live in South Africa, as well as the Immigration Act 13 of 2002, as well as immigration regulations to that act. I think, as well as a white paper of international migration that has also worked in some way to facilitate, to include provisions that facilitate, regularize, and regulate different categories of voluntary migrants. So in South Africa, one needs an asylum seekers permit, often referred to as a Section 22 permit, that allows asylum seekers to stay in the country, to do work, or to conduct their studies while they're waiting for an application status for their refugee to be processed. So once, or if that does succeed, they would get a refugees permit, which is referred to as a Section 24 permit, which would recognize them officially as a refugee in the country. And it would be valid for about 2 years, and then must be renewed no less than 3 months prior to expiry. So these refugees who hold this permit may also apply for a refugee identity document as well as a travel document, being able to access most of the same rights as South Africans, perhaps except the right to vote. So having a refugee status grants one protection from the South African government, which would mean that they can't be forced to return home until it's safe to do so. But the latest developments, as recently as 2019, the Department of Home Affairs published some refugee regulations that enable implementation of a Refugees Amendment Act, which now drastically limits the rights of refugees and asylum seekers, such as through ways such as losing refugee status for voting or participating in political activities in their countries of origin, and also seeking consular services from their countries of origin. For example, is through requesting a birth certificate at a consulate. So this tightens also the administrative rules for applying for asylum and limits asylum seekers' rights to work and study in South Africa. So those who are not refugees or not considered by the state as such have to apply for one of the permits provided for in the Immigration Act, such as study, business, work, critical skills, permanent residency, or spousal, or these are commonly known as temporary residence permits. So we see a sort of interaction between the two regimes of governing migration that upholds a dichotomous status quo, such that people are generalized essentially as asylum seekers or economic migrants on the basis of what is known about their countries of origin, which replicates the sort of bifurcation of the global migration governance regime that seeks to distinguish between voluntary forms of mobility, such as economically motivated migration, and more forced forms, such as refugees. And this is more pronounced in the context where the country is struggling with a heavy backlog for processing refugee applications, which is a very administrative, bureaucratic problem that gets blamed on economic migrants for clogging the system. So the rejection rate is for all these refugee applications also stands at an appalling 96%. And there's been a lot of closure of refugee reception offices in the country to undermine the rights of asylum seekers, and also where there's been court orders to open them, they have not necessarily been upheld. To complement, the country also has also introduced a border management bill, which has seen the setting up of a border management authority via the act, which reinforces securitization of borders in the name of protecting national interests, as well as this would also see asylum processing pushed back to the frontier, like outside the border. And amongst these sort of externalization, it was, I think would be the term, in a bid to ensure effective and efficient border law enforcement functions, to contribute to the facilitation of legitimate trade, secure travel, and preventing smuggling, trafficking of human beings and goods. Again, we see the same language that we're hearing about here in the UK. So the final thing is sort of the bureaucratic closure of, or exclusion at least, of these economic migrants who, rather than being seen as genuine asylum seekers, will likely be denied sort of access by default. So for example, the refugee reception office at the Zimbabwe-South Africa border is open to all migrants on paper, but it has also developed de facto gatekeeping methods of barring migrants from Zimbabwe, for example. So in principle, one of the requirements is that a person enters South Africa through a border would have to claim asylum and issued with a Section 23 permit, valid for 14 days, and then which would then allow them to report to the nearest refugee reception office. And while these permits are also issued at the border, but not everyone receives them. And so most Zimbabweans as well resort to border jumping. And when they eventually approach the reception office, they speak about the experiences of sort of being led to an office, and then before they know it, they're at the back of a police truck, and being arrested for deportation. And these are some of the subtle ways of undercutting the right and also criminalizing migrants, because they now know better as well than to go to these offices and would rather stay undocumented. And then finally, there's a lot to talk about as well around the COVID pandemic, where we also saw refugee reception offices closing, which led to a lot of challenges of access to services amongst refugees and asylum seekers because of lack of documentation, which in turn affects their livelihoods. So I think I will leave it at that, and over to you, David.
Brilliant. Many thanks indeed, Kuda, for the comparative example from South Africa. And I particularly like the way that you highlight, I suppose, the linkage or the intrinsic connection that in some of the South African government's measures you can see on the one hand between kind of what's seen as economic migrants or economic migration, and how that then links to who is seen as a legitimate asylum seeker, and the fact of falling into one or other of those categories or not complying with the border regime leaves one open to deportation and other measures. So thank you very much for bringing those examples to our attention. This brings me on to our last speaker. Before coming to our last speaker, I will just remind you that if you do have questions on the basis of what's been said so far on the topic, please do add them to those which are starting to appear in the chat, and we'll come to those in 10 minutes or so. So for our last speaker, I come to Regina Jeffries, who is joining us from the Center for Law, Diversity and Justice at Western Washington University in the United States. Regina's work focuses a lot on the arrivals of asylum seekers by boat, I think particularly in the Australian context. And therefore, we're really pleased, Regina, to have you with us to talk about the particular political hysteria that seems to be aroused by these kinds of boat arrivals, and that, as Anna mentioned, we're starting to see develop around the English Channel as well. So over to you, please.
Thanks very much, David. So the political hysteria around asylum seekers who seek to travel by boat, or boat arrivals as they're more colloquially known, isn't unique to the UK, as many of you well know. It's an issue that's evoked a particularly extraordinary response in the Australian context on both sides of the political spectrum. And the blueprint actually for the Australian response can actually be found in the United States' earlier use of interdiction and offshore processing for Haitian asylum seekers beginning in the early 1980s. But in Australia, the sustained political focus on boat arrivals stems in part from geography. And as an island nation, of course, Australia has no land borders. And so there are only two ways for people to arrive in the country, by sea or by air. And Australia, like many other countries in the global north, has imposed universal visa requirements and a variety of other measures meant to identify and specifically prevent potential asylum seekers from traveling to the country by air. In fact, the Department of Home Affairs envisions the border not as a specific territory or place, but as a continuum over which to exercise varying means of control at progressively earlier points in a traveler's journey. And that regime means that travel by boat is functionally the only mode of unauthorized or illegal arrival. So when does the political hysteria in Australia really find its start? I mean, in the 1970s, Australia's government at the time responded to boat arrivals fleeing the aftermath of the Vietnam War in a very different way. They accepted and resettled large numbers of refugees arriving by boat, but the situation today couldn't be more different. And as part of the fieldwork for my doctoral thesis, I interviewed a number of different solicitors and current and former government officials involved in implementing some aspect of Australia's asylum framework. And one of the interviewees recounted the time in 2001 that they watched the Federal Court of Australia hear arguments in the Tampa Affair. And some of you may remember that that was the case where a Norwegian freighter, the MV Tampa, rescued over 400 Afghan asylum seekers aboard a stranded boat in the Indian Ocean. And the Howard government at the time refused to allow the Tampa to disembark the asylum seekers on Australian territory. And that case was heard just after the events of 11 September 2001. And the solicitor recalled being struck by the Howard government's argument that disembarking the asylum seekers was actually an issue of national security. And that view of people fleeing persecution or other serious harm as risks to be managed or eliminated rather than as a humanitarian concern is one that characterizes the political and legal context in Australia today. The perception that boat arrivals are jumping a queue as well as racially charged rhetoric, have also contributed to a hardening of public opinion, while policies have also become increasingly hardline over time. And that's happened despite the fact that large numbers of boat arrivals have ultimately been found to be refugees. There's not necessarily this sharp division between quote unquote economic migrants and asylum seekers and refugees. High percentages are actually found to be refugees, and that does not actually seem to change the public's perception of this issue. And it's happened also despite the fact that the number of asylum seekers who travel by boat to Australia is actually relatively small. And as boat arrivals decreased between 2003 and 2007, public debate on the issue received less attention. But in 2008, numbers of arrivals began again to increase and political rhetoric followed course. And then by 2010, the Conservative government instituted and reinstituted a number of punitive policies aimed at deterring and punishing people for traveling by boat, including a two-tier system for unauthorized versus authorized arrivals that has left a large number of refugees in a permanent state of temporary status. And interestingly, Australian governments have justified these policies in part based upon their relatively large intake of refugees through the controlled humanitarian program. But with COVID-19, even the humanitarian program has suffered significant setbacks since Australia closed its international borders to a very limited subset of travelers in March 2020, and only reopening for the most part in December 2021. And border security, again, in the context of the pandemic, has become the default Australian response. And so throughout the last 20 years, successive Australian governments have quite successfully used border security generally and boat arrivals in particular as a cudgel to garner votes. And interestingly, much of the rhetoric around stopping the boats has also allowed political and legal figures to co-opt language of humanitarian concern for the lives of those traveling by boat in disdain for people smugglers to justify increasingly harsh deterrence policies, including offshore detention. The political effectiveness of boat arrival rhetoric in Australia can't be overstated, and it's clearly linked to broader conversations about unauthorized migration and the criminalisation of asylum seeking. But despite the rhetoric and policy, people continue to attempt to reach Australia, though they're now often stopped by law enforcement in third countries, often working in concert with Australian Border Force officials. And no amount of deterrence policies, including pushbacks or offshore processing, have changed the fact that people continue to face circumstances in their home countries which compel their movement to countries like Australia. And the UK's decision to engage in similar policies will undoubtedly lead to tangible harm of asylum seekers without delivering on stated policy goals. And I'll leave it at there, and happy to answer questions.
Thank you ever so much, Regina. I mean, you've taken us through a great deal of Australian history in relation to the development of these kinds of ideas. And, you know, having followed the UK debate over the last bill very closely over the last year or so, there really are such strong resonances. And, you know, I think it's little secret that, in fact, the Australian model has proved to be an attractive one and partly underpins the new plan and the Nationality and Borders Bill, or at least quite a number of the provisions. So thank you very much for leading us through that case example, and also, again, trying to, I think, give some real substance to why it is that boat arrivals seem to be so politically sensitive. I mean, partly for island states like Australia and the UK, they are really the only remaining means of arrival. I mean, in the UK, particularly, you know, with the shutdown on flights, you know, Channel Tunnel not running so frequently, etc. You know, boat arrival, that's when boat arrivals surged, and you can see a very clear parallel with the kind of situation that Australia was looking at that point. So, you know, having shut off a number of other routes for people to seek protection, this seems to be the latest battlefield for addressing that. I can see that there are a number of questions in the chat box, and in a moment I'm going to go to our speakers in turn, first to Anna, then to Kuda, then to Regina, to see if they would like to pick from those questions and offer a response. If I could add one in, though, in my capacity as chair, and I think this is really a question for all of you, Anna in the UK, Regina in Australia, Kuda in South Africa, how effective has criminalisation been as a measure for achieving whatever aims seem to be behind these pieces of legislation? does prosecution work? Is it an effective strategy? Anna, you talked a little bit about whether it was in fact used. Who is the audience for the criminalisation? Is it the asylum seekers and deterrence effect, or is it a broader public, or some mixture of both? So there are probably a couple of questions there, but in essence, it's really about how effective on their own terms are these criminalisation clauses. So there are a number of questions here, and we may have one or two rounds of discussion, but if I can go first back to Anna, and if you just select the questions and give a brief mention as to which ones you're answering.
Thank you, David. So shall I pick George's questions, which was the first one, and it was a general question for everyone. So in terms of the success of these deterrent measures that we are looking at, I mean, in the case of the UK, the UK government has been implementing a range of acts, pieces of legislation. I've been following them quite closely, particularly since New Labour government. The use of criminal law for deterring and penalising asylum seekers had been, at least on paper, a significant tool in Labour's plan, and it continued to be for this government. Whether or not it has been successful is I think is a matter of debate. As lawyers and socio-legal scholars know, the law has very limited effect on these issues, particularly, whereas refugee lawyers would, of course, know, there are broader issues of widening social and economic inequalities that, even though these changes to law try to tackle and try to displace the way in which human movement happen, that's impossible to do. I suppose Brexit has also created further difficulties because of the pull out from the Dublin regulations and the impossibility of returning people to European countries. And I guess the whole scenario points to and emphasize the importance of multilateral work, that this is not a national state focus area, that it needs to be tackled through cross-national efforts and not just legal efforts, and points to the failure of those strategies, which not only will not deter people from seeking safety, but also increase the risk to life that all these measures, as we have seen in the UK, with the tragic death of 27 people in the English channels, these measures will continue to increase the risk to life of those seeking protection.
Many thanks, Anna. Kuda, can I go to you next?
Yes, thanks, David. That's an important question. In the South African context, the criminalisation, for example, we do have also like the Trafficking in Persons Act, which also tries to place some kinds of penalties to. There's also conflation of trafficking and smuggling. So you find also smugglers being also caught in between in some of these debates, or criminalized or vilified as people who are also, probably complicit in trafficking, or just be criminal by virtue of assisting migrants to cross the border. What that does is obviously increases some of the costs that migrants incur in terms of having, it becomes a very, criminalization makes the space, if we were to think of it as a criminal network, the incentives have to be a little bit higher to do the kind of work. So the costs get higher as well for migrants to cross, and they have to fork out more monies in order to be able to cross, which, if there were to be avenues, legal avenues, or pathways to migrate, that money would be going back to the state. If they were to think about it as, how to sort of leverage some of this, that's how they possibly could look at it. So there's that aspect. And then criminalizing the migrants themselves is also hasn't really been working as well. It also brings more costs again in terms of deportation. People get deported and then they return. They just, people get arrested. Then the following day they're back again. Not to mention the higher risks that they have to also have to incur. So it really hasn't worked in any way, the criminalization of people who are on the move, and I also don't see how it's, people will always find ways, and they will find routes, and the smuggling networks will only get sort of smarter and smarter, and again, the costs are only going to get higher and higher.
Many thanks, Kuda. And coming to Regina, which question would you like to take?
If you don't mind, just to have a brief word on the criminalisation and the effectiveness of that, because I think the Australian context is particularly instructive, particularly in relation to multilateral sort of regional efforts as well there. So in terms of whether criminalization is effective, it honestly depends on who you ask. Because if you ask the current government in power, they'll say that it's very effective. And in fact, the current prime minister has a statue, a trophy that he stopped the boats. But in fact, criminalization provisions haven't stopped people from seeking asylum. They don't change the root causes of movement. And there isn't that acknowledgement that essentially what the government's doing is stopping people at earlier and earlier points of their journey. So they may not be reaching a boat to try to seek asylum in Australia. They might be stopped in a third country like Indonesia, and prevented from making further progress. So there's also, I think, what's instructive for the UK context potentially is that there's also a significant danger of transforming the conversation around asylum seeking as sort of as a humanitarian, essentially humanitarian regime, into more of a law enforcement type regime where you see conflation, as Kuda said, conflation of trafficking and smuggling, which happens. And you see this in Australia's multilateral engagement with countries in Southeast Asia, in particular in the Bali process, where the rhetoric is to stop people smugglers, that Australia has a humanitarian concern for people who might seek asylum by boat, and out of that concern, they would like to stop people trying to travel to Australia by boat. So, deterrence measures, as David, you alluded to earlier, simply push people towards a different available path. So preventing asylum seekers from traveling by air, for example, results in people taking to boats, and that has not changed.
Thanks a lot, Regina. I mean, the three answers that you've given give a real sense of a direction of travel, at least on the part of the three governments that we're discussing here today. And I just wanted to end, or move towards an ending, with a question that Kuda, you yourself asked, which is, well, who takes the lead internationally now? Who is kind of the shining model of, an approach that isn't based on this conflation between securitisation and, asylum seeking or response to refugees? Where does one go for those kinds of responses? Are there alternative models which we can point towards on the global stage? And I wonder if I can just allow you to think about that for a moment, whilst I turn over to our fourth speaker, George, who I see has one very particular question in the chat box. So George, would you like to take a minute or so to respond to that? And then I'll return to the others for thoughts on what other models there might be to contrast with the criminalisation one.
Yeah, sure. This is the question on whether the bill is in violation of, is there scope for the bill to be reversed by the judiciary? So, I mean, I'll start off by saying, I can have a stab at this question, although, the interaction between the judiciary and Parliament and sort of constitutional law is definitely not my area of expertise. So please correct me if I'm wrong. I think while the courts may find that certain provisions of the bill could be incompatible with the convention, and while the judges may make reference to that in their judgments, I don't think the judiciary or indeed any judge would have the power to reverse any provisions of the bill for two fundamental reasons. I mean, firstly, the judiciary can declare law passed by Parliament as incompatible with the UK's international obligations, but it wouldn't have the power to reverse any act of Parliament. And secondly, of course, the convention is non-binding, unlike the sort of the European Convention, and so there wouldn't be any I think legal basis to sort of declare necessarily a provision to be incompatible, such that Parliament would then be required to reverse it. So the answer is I think the short answer is no. I don't think there is any scope for the new act to be reversed by the judiciary, but others may have a more sort of nuanced take on that.
Well, many thanks, George. I mean, I think it's important to clarify the convention is binding on the UK, but it's just not incorporated into our domestic law as the European Convention was. So only those provisions that have been incorporated would be ones that we'd be able to rely upon, as opposed to the kind of comments that you're suggesting from the judiciary. Okay, so if I can go back to the three speakers, can I just end with a minute about, well, if you had a minute alone with Boris Johnson or the Premier of South Africa or Australia, what would be the alternative model? Is there another country that takes a different approach to these kind of issues that would be useful to put on the table? So if I can give you a kind of 60 seconds on that. Anna, any thoughts about that?
Unfortunately, I am not very optimistic. I mean, I'm quite familiar with Latin American regulations and policy developments in this field, and there has been quite a lot of work around refugee protection in South America in particular, although of course the situation of particularly Venezuelans refugees is it's quite worrying, but there has been quite a lot of development at the level of the Mercosur around, cross-border collaboration and solidarity. But I am not, perhaps as I said, very positive about whether those proposals can be copied as other more restrictive proposals. The Inter-American Court of Human Rights also has been quite progressive in their judgments around migration and refugee law. So this is something that, again, it's a more progressive avenue to think about policymaking.
Many thanks. Kuda?
Yeah, it's a very interesting question, I think. Maybe to kind of touch on, I know Nick had a question there around, the UN, and, some of these actors are severely limited, particularly with the kinds of institutional frameworks that operate within, the language, the management approach, the managerial approach. It's really, really rigid, and the relationships between sort of the UN and the South African government, for example, do not necessarily allow them to do much. So I don't really see sort of much coming out from that. The bilateral stuff or multilateral could have been an opportunity, but with the Valletta agreements and all, we can already see that there isn't so much possibilities. And you can't really trust African governments to have the interests of the refugees themselves at heart. Which is why personally, I've sort of been caught up in sort of wonderings about some, writings around sort of the decolonial literature, thinking about transformative approaches to even migration law, because we seem to be also constricted by the kinds of language and the legal jurisprudence that comes from sometimes colonial and also oppressive or laws that try to divide people and then hierarchize society. So in that front, there's a great promise from some of the work that's really trying to trouble the sort of ethical implications of thinking of transformative immigration law, that where we don't necessarily take those as baselines and normatives. We actually need to trouble where some of these laws come from, and whether they can actually allow us to transform society.
Thanks, Kuda. Regina?
Thanks very much. Just to quickly draw upon points made both by Anna and Kuda, in the context of Latin America, I'd also say that Mexico actually has a pretty progressive asylum framework, though the practical implementation of that framework often leaves much to be desired. But I share the feeling that the trend is not positive in terms of these types of restrictions. And then to Kuda's point as well, about looking to more sort of transformative changes and rethinking some of the ways that we've talked about these types of changes in the past. I mean, people have talked about protected entry procedures and in different procedures that might allow individuals to move in ways that would prevent dangerous journeys. But at the same time, I think there has to be a recognition of the sort of mixed status of many of these movements, which much of what we're talking about in terms of the refugee definition or even complementary definitions don't necessarily cover. And I think that needs to be part of a broader conversation, as Kuda has said. So I'll leave it at that.
Great. Well, many thanks for those comments in response to what I know was a fairly mean question to end with. Also, I'd just like to point to one of the contributions to the chat about the context of India. And I think, if you've got a couple of minutes at the end, it's certainly well worth reading through that. So thank you very much to the participant who gave that complimentary example as well, which I think points to some extent in the same direction. Overall, it's been a really good discussion today, but I think that's all we've got time for now. So allow me to draw the proceedings to a close by expressing my thanks to colleagues at the RLI, to George from the Refugee Law Clinic, to our three fantastic presenters, and also to each one of you for participating too. We look forward to seeing you all for the 5th seminar in this series, which does start to address these questions about international cooperation and how that works in the COVID or post-COVID context, around issues like dealing with irregularity, with resettlement, with safe pathways to protection, etc. The next session next month is called All Friends Together, ? International Cooperation in the Asylum Field. And it will take place on Wednesday, the 9th of February at the same time. All of the details of that seminar are to be found on the RLI website. But until then, many thanks once again, and goodbye until the next session.